We're still going to give Katie 2 weeks to finish.
Yeah.
All right. Janice
Not a
Jackson.
second.
No action,
motion.
no action.
I'm Janice Jackson, and I appreciate the board giving me this opportunity to come speak before it on the issue that is on the agenda for today. It had been previously placed on an earlier agenda without notice to me, and I fortunately caught it and had it removed so that I could appear to explain my side of the story in this matter. I am a registered qualified voter of the first Supervisor's District of Madison County. I have been living in that same place, just a few blocks from Mrs. Jones' house in North Bay since 2006. I'm born and raised Jacksonian, moved out here, joining two of my brothers that had been living in Sandalwood and Ingleside for the last 30 years. I am a Mississippian. And I came out here to be in a safe community and with high standards, and I have found all of that to be true. I got interested in the position of election commissioner as I had helped my parents in their retired years. They volunteered at the polls in Hinds County. And as old as they were, I had to take them down every night at 7, 8, 9, 10 o'clock to turn in the ballot box, which is how we did it back in the day. But nonetheless, I got interested in it. And your circuit clerk was recommended to me to go talk to about campaigning. And I looked into the law of it, and I realized that I don't need a party recommendation. It doesn't work that way, that at the election commissioner level, I simply fill out an application, and I get at least 50 signatures of qualified registered voters from my district. And I went out and spoke with Anita Ray. She's joined us here today. And I got my paperwork, and I got my recommendations on campaigning. I spoke with her a couple of other times about the process of exactly how to do this. And on the phone. And I understood that she asked me to come on in and hurry up and get that done so I can get my 50 signatures approved by her to ensure that the people that signed were actually registered voters, which is a part of the process. And on two different conversations that we had, I wanted to be sure that it was going to get over to Ronnie Lot's office, the Hinds County Chancery Clerk, the Madison County Chancery Clerk, and this board's clerk. And she said that would be no problem, just get them turned in early. And I did. As a matter of fact, my husband, who I'm going to call as a witness here in a moment, took him out to Anita Ray's office on June the 2nd and walked up, asked for her, and I believe she was away in a meeting, so he ended up talking with a deputy clerk and said, I'm here to file these papers which say qualifying statement of intent, candidate for election commissioner. And the deputy clerk took the papers out of his hand, walked over to the copy machine, and went and dropped them in a drawer. He witnessed her do that. And then she came back and gave a set of papers back to him. Well, after a little after the deadline, June the 6th, my husband called. He's retired. He's got a lot more time than I do. So he called Anita, and she said, what are you talking about? We don't have your papers. And he says, well, you certainly do. I had brought them up there myself. And I had your office stamp them. They said June the 2nd. And she said, please bring those up here and let me look at them. And sure enough, he did. And sure enough, she called the deputy clerk over there to say, what in the world is this? And the lady remembered my husband coming. And she said, oh, I put those papers in the financial file. That she had been having, I think, a lot of people as I understood it, coming in to file maybe budgets or whatever they were filing that day. And of course, I'm sure she was busy. And so she just thought this tall, good-looking man right here was coming in to file some financial records for one of y'all's agencies, which I don't mind her assuming that, but she took it and she dropped it in the drawer where the financial records were. So when my husband got up there and got to talk to Anita Ray, Anita asked her, she said, yes, I'm there, right there. And so she walked right over there to the drawer, and she pulled my papers out of that drawer. And Anita said, I am so sorry. I am so sorry. And I said, well, I am too. We try to do our best and everything. And I knew I trusted you because she's an honest woman. I've known a lot of people that would verify that. She's a trustworthy elected official here in Madison County. And I think we get a lot of amens around here, those that know her. I knew for 100% that she was going to take those papers over to Ronnie Lot as soon as she checked to make sure that I had 50 signers. Because if I didn't have 50, they weren't going anywhere anyway. So here we go. We got into this situation. And I called Mr. Lot to speak with him about it. And after I found out I'd been put on the agenda to get my application thrown out, it was to be rejected. And I am so grateful that today we're going to have a discussion about it rather than, a preemptory rejection. Because my research, I'm a lawyer, by the way, practice up here in Chancery Court quite a bit. And I looked into this. And I found out, and I've spoken with Katie Snell, Miss Snell, today, and I found that the Attorney General had a question very similar to this question come up from the Hinds County Board of Supervisors on July the 13th of 2012. And Katie, do you need an extra copy?
No, I have her.
Okay.
But wait, I got one question. What authority does the Board of Supervisors have over this election matter?
Well, y'all reject it if it's not properly, if all the steps weren't properly.
Whose
done.
responsibility is it to take it from the circuit clerk to the chancery clerk?
It's the candidates.
It's the candidates. It's not the clerk's responsibility. Anita? Okay. Were you saying that it was Nita's responsibility to take it?
I'm
from-
not nearly finished. I'm going to talk about Supreme Court here in just a minute,
Okay.
okay? You might want to sit back and relax. I've got an opinion here that was entered by the Attorney General's office that was requested from the Board of Supervisors in Hinds County in 2012 in a very closely related situation.
Go ahead, Ms. Jackson.
And I thank you. Appreciate it. Come on. And I've talked to the Attorney General's office, and I've talked to the people that are in the elections or area. And they assured me that their opinion on the law that you just referenced, Mr. Baxter, was their opinion. And I said, well, now is that opinion binding? Well, no. No, it's not. And I already knew that because I had looked up the law on it. And I have provided it to Mr. Lot some days back, and I don't know whether or not he shared it with you. I sent it to him, or talked with him about it, and sent him some other case law that I'm going to talk about here today, because this is what I'm going to talk about somewhere else if I end up having to go somewhere else. Now, this case right here is a case that I sent over to Mrs. Snell, and it is a case from the Mississippi Supreme Court that trumps every Attorney General opinion. Now, this case is against George Dale, our election commissioner. And it's about an Attorney General opinion. Lo and behold, back in 2005 and before, our Supreme Court, this is the most recent one I found, but there's plenty of other ones, okay? It says, Attorney General opinions are not binding. They are not binding on the Board of Supervisors. They're not binding on George Dale. They're not binding on anybody, particularly the Supreme Court.
Can I ask you a question real quick for you? Who's George Dale?
He's our insurance commissioner.
Well, I thought you said he was an election commissioner.
I'm sorry, I was making an analogy to the Attorney General's opinion is not binding on this body.
Okay.
I'm sorry, did you understand that, Mr. Baxter?
I guess when you brought the insurance commissioners, I just kind of got a little confused here. Are we talking about the elections or insurance?
We're talking about the Attorney General's opinion.
We know that's not binding.
Okay, well, I have proof that it's not binding.
Okay.
Okay, and I've given that proof to your attorney, and I have a copy of it here if you would like to have a copy of it.
I will confirm that, and most of you all know that Attorney General opinions are not binding on the Board of Supervisors, or I'm sorry, on the courts. They're advisory opinions for the board. They do offer some level of protection, but just generally to operate under, but no, they're not binding, and a court can overturn them, which is consistent with what Ms. Jackson's provided.
In other words, the concept of strict compliance as applied in the Attorney General's opinion is not enforceable in a court of law. Because we have Supreme Court cases, many of them, and I've already forwarded them to Mrs. Snell. And I'm going to read from one right now. It's called Rogers versus Holder. It's a 1994 Supreme Court case, and it addresses the concept of strict compliance. And it says, Supreme Court says, relying on several other cases that also say the same thing, it says we require strict compliance with statutes concerning absentee ballots. So, Mr. Bishop, I don't want to get anything confused here. We oftentimes work with analogies at the Supreme Court level for sure, and case law interpretation, and there simply is not any particular Supreme Court case about whether an election candidate has to carry the papers strictly to the Chancery clerk or not. It's just no case law on it. But this is about the closest thing that we can get, and it says we require strict compliance with the statutes concerning absentee ballots. Nonetheless, okay, here's the loophole. Nonetheless, absent evidence of fraud, and I'm not alleging any fraud here because I trust Anita Ray, and I have good reason to, because I've had people, even Ronnie, everybody I've talked to about her, says she worked hard for this post and she wanted it, and she's a good person. I'm not alleging fraud or any other wrongful or intentional conduct. What I'm alleging is what the Supreme Court says that I am entitled to be considered in this decision that y'all are going to make about my application. And that is called technical irregularities. Now, if this wasn't the best example of a technical irregularity, I can't think of a better one. But it says it will not invalidate, in this particular case, an election, because the analogy is absentee ballots. But it goes on to say that if a statute does not expressly declare that a particular act is essential to the election's validity, or that omission of a particular act will render the election void, the statute is considered directory rather than mandatory, as Mrs. Snell had mentioned earlier. I have a court reporter here that is going to be taking a record and accepting exhibits. Mr. Lot, do you accept any exhibits, or shall I just have that totally handled through my court reporter? Okay. Well, I'm going to submit them to her and let her stamp them. Or do you have a stamp for them? Okay. Can we do it both ways? Yes, ma'am. Okay, great. I have got 2 exhibits that she has prepared and already stamped. And she has stamped as Exhibit 2 my papers that I had, my 50, actually I had 53 signatures, but that were stamped June the 2nd of 2006, and she has marked it as Exhibit 2 to this transcript. And would you like for me to step over there and let you mark it as well? Okay.
This is the one we accepted, or is filed stamp on here?
Okay. Well, I don't have a copy of that one.
Okay.
But I would also like to have that one entered as an exhibit. I have a copy of it later on.
Yes, ma'am.
Okay, I don't have that one.
Okay, well, I need to have
I've never
this
seen
one.
it.
I have to keep this, this is your file, and paperwork.
Okay.
I can make you a copy of this.
Okay. Could you make it for me to give to my court reporter?
Yes, ma'am.
For record? Okay, great. If you could make a copy of those signature pages too, I would really appreciate it. Okay, thank you. So that exhibit will cover these two exhibits. We'll get that one back and we'll use it as our exhibit number 1. You've heard my version of what I personally experienced in this process, and I would like to call Jim Powers, who is my husband, to also come up here and be sworn by this court reporter as being under oath to tell about his experiences in trying to push through my application. Mr. Powers, would you let the court reporter swear you in?
Raise your right hand. Do you swear or affirm the testimony you're going to give today in this call is the truth, nothing but the truth, so help you God? Thank you, sir.
Mr. Powers, would you state your full name and your address for the record?
It's James W. Powers at 113 Greensview Drive, Madison, Mississippi 39110.
And are you married to me, Janice Jones?
I am.
And would you tell the panel of our supervisors here about how you became involved with the circuit clerk's office and handling what's going to be marked as our exhibit of these papers right here?
Okay, Janice had gone out and procured the 56 names, I believe, that were on the petition, and I admire anybody to do that in 85 to 90-degree weather, knocking on doors, and I was very pleased to see, and she was very pleased to see the openness that the people had to her, and within the course of about 3 or 4 days, she had completed the task and had asked me to take the petition to the circuit clerk's office, which I did. And as she said, I brought the package in, it was date stamped and filed. And I asked, is there anything else we got to do? As Janet said she'd ask. She said, no, we'll take care of it. And she said it in a very authoritative way, and, I don't do this every day, so I was like, great. And left, and we,
And what day was that, Mr. Powers?
forgive me, but I'm not quite sure of the date itself. The date is June the 2nd for the filing.
So it was June the 2nd when you went up there and went into the circuit clerk's office and handed over these papers?
Yes, as a matter of, yes, it was. And then,
What happened next?
well, they gave me back a copy of it that was date stamped and so forth and signed by the deputy clerk. Returned home, and we kind of expected some sort of notification, and the deadline passed, but we were still pretty confident that everything had been taken care of. And we made a phone call, And,
Did you make a phone call?
yes, I did.
And did you call Anita Ray?
I did. And
What
we,
happened after that?
we chatted, and at first, there was a lot of confusion because she had not seen the paperwork. It was the deputy that had taken the petition, date stamped it, and instead of passing it to her to validate the names, that part didn't happen. Now, when I called her to follow up with that, at first, she was like, "Are you sure you came to this office?" Which I can understand, and getting, seeing 1,000 people a day. But I pulled out I called back again because I found the date stamp thing with the deputy's name signed to it. And by the time I got back to Canton, all the names have been checked and essentially qualified to be able to put on the ballot.
Was she able to verify that that was her file stamp on June the 2nd that was placed on my application? and
Yes. Yes, she did. So at that point, it was like, let me get this over, Mr. Lot, and, again, we expected to hear something. And I guess about the next thing we found out was that you're going to be denied, a place on the ballot by the Board of Supervisors.
Thank you, Mr. Powers. I'd like to call Anita Ray as my next witness. Ms. Ray, would you allow my court reporter to swear you in?
Do you swear or affirm the testimony you're going to give today in this call is the truth, nothing but the truth, so help you God? Yes, I do.
Ms. Ray, just for the record, would you state your full name and your official position with Madison County?
Yes, Anita Ray, Madison County Circuit Clerk.
Okay. And do you recall the first day that we met?
Yes,
And I came by your office to introduce myself and to talk about campaigning and that sort of thing?
it's in the office, yes.
Yes. And did we talk a couple more times, maybe on the telephone, before we actually ended up completing the cycle of what we did?
Yes,
Okay. And did I ask you, do I need to come back and get them from you and walk them over to Ronnie? Did I ask you that question?
yes. We talked about how to, what the process was
Right.
to get the names, to get the petition, and at least 50 names, and then you needed to get them over to Ronnie. Yes,
And did you tell me that did I ask you, do I need to come back out here after you've checked the signatures to get them over to Ronnie? You remember me asking that?
yes.
And you told me that you were going to take them over.
No, no, I never told you that. I never told you that I would, because that's never been my policy to take anything over to Ronnie's office for any candidate.
And how long have you been serving as the circuit clerk?
I've been here for 7 months. It's never been my policy to
So
do
have you
that.
ever had this happen before?
No,
Okay. Well, when I asked you if I needed to, do you remember me asking you, do I need to come back out here? Did you remember me asking?
yes, well, either your husband or you, because Ann also, and I have my 2 deputies here with me, and Ann, I spoke to your husband also
Okay.
about it.
And you don't recall specifically telling me, you don't have to come back out here, I will get these over to Ronnie.
No,
Okay, well, that's all we need from you. then.
okay, thank you.
I appreciate it. We'd like to call Mr. Ronnie Lot as our next witness. Before we get started with Mr. Lot, I'm going to have my court reporter mark the certificate of petition signed by Anita Ray, and Ronnie file stamped it June the 29th. And attached to it is my qualifying statement stamped by Anita Ray, June the 2nd. And the next are the 6 pages of signatures that Anita has checked off where she says that these are qualified voters. And I'm going to ask my court reporter to mark this copy as Exhibit 1 to our proceeding here today. Ms. Lot.
I'm standing in this office, I've been sworn, and I'll be glad to humor you and do this again, even though it's not a court of law, but go ahead.
Swear or affirm the testimony you're gonna give today in this case, the truth, nothing but the truth, so help you God.
Let me also state, as an officer of the court, I'm not required to take an oath. So when we do get in the court of law, we just want to make sure everything's clear.
Yes, ma'am.
I appreciate your help on
Yes,
that.
ma'am.
Mr. Lott, do you remember when you first heard from Anita about this mix-up?
I cannot recall whether you called me first or she called me, but I think it was basically a simultaneous call
Same
saying basically the same day that we had already approved, I believe, on the 15th. When did we approve that? The board approved the election commission? On the 20th. We had already approved the election commissioners, and I believe that you found out about that. And I said, well, those were the papers that I had turned in to me. So those are the ones I turned into the board for their approval.
Okay.
Then you told me, well, you had turned yours in to the circuit clerk. I said, well, I had not received them in the chancery clerk.
And did I tell you that she had told me she would bring them to you?
I did not recall that, whether you said that or not. You just said that you thought they had misplaced them.
So I could have told you that she said she
You
would
could
bring
very
them to
well
you,
have.
and you
Yes,
just
ma'am.
don't recall it
Yes, ma'am.
because-
You could very well have.
Okay, that's all we want from you, Mr. Lott.
Okay,
Appreciate it.
thank you.
That is what I have to submit to the board to consider, upon advice of counsel, what's going to happen next here. And I would certainly need to know of that decision rather quickly, however it's handled, because I only have 10 days to file an appeal with the circuit court. And that, I don't know exactly, I think that appeal time runs when the board enters a
Starts after the board has a final decision.
Anita, can you come up here real quick? I got a question for you. There. What's the normal, if I was filling out my paperwork and I dropped it off to you, what's the normal process? You have to stamp it and you keep it overnight, or how does that work?
I'm going to jack to what the normal process
Hold on,
is.
it's not a court of law. She's going to answer the question that I asked her, and you can sit down. You need to sit down. Ms. Jackson, you need to sit down. Sit down.
I'm here to make the
Sit,
appeal record.
you need to sit down. She has the mic. You need to sit down.
The normal process for an election commissioner is they bring in a petition with the names on it. We check the names to make sure they have a significant amount of names, the appropriate amount of names within their district. Then we call them, and we do the letter to send over to Ronnie. We call the candidate to have them to pick it up. And the candidate comes back, picks it up, brings it over to Ronnie. I go by strictly what the Secretary of State's website says. And the Secretary of State's website says that the candidate brings it over.
Okay, when you all found out that this mistake occurred, how much time was left to get it over to Ronnie's
They
lot?
filed the petition on June the 2nd. June the 6th was the deadline. I had no knowledge that it was in my office. June the 6th was the deadline. I had no knowledge that it was in my office until around, I think it was June the 23rd or 24th. And that's whenever I checked the names. I had called Ronnie. Matter of fact, I called Kim Turner over at the Secretary of State and asked, she's the attorney at the Secretary of State, and I asked her, what should I do? And she said, go ahead and check the names on the petition. And she said, go ahead and get it over to Ronnie. And so
Okay,
that's,
so what date did it get to Ronnie's office? 29th? Okay.
whatever date is on that letter there that I had checked the petition, whatever date that is, it was around the end of June. 29th, okay,
Okay, thank you.
okay.
After hearing Anita's testimony, I certainly need to add an additional statement to.
Can I ask a question real quick? I hate to interrupt you, but can I ask you a question?
Please ask me one, Mr.
You were
Bishop.
running, you were wanting to run for election commissioner.
Yes, sir.
Is that correct?
Yes, sir.
And so before you did all this, you searched what you're supposed to be doing.
Yes, I
Is
did.
that correct?
I did.
And you bringing that over here by yourself, or your hands was nowhere discovered?
Sir?
You never discovered that you have to deliver this yourself?
I knew
Never knew
it-
that? I mean,
I knew that it had to be submitted to Mr. Lot by 5 o'clock on June the 6th.
and you just said anybody could take it up there for you.
Anita told me she was going to take it.
I think she didn't tell you that.
Well, that's a matter
Okay?
to be
So my
decided.
point is, you're an attorney, is that correct?
I am an attorney.
Okay, so I would think, with your knowledge of laws and statutes and regulations, that you would have picked that up somewhere. That was your responsibility to take it to the Chancery Clerk.
No, it's not. It's my responsibility to have it there. And I asked Ms. Ray.
Okay, and you put that responsibility on Anita?
Well, I asked her, I said, what do I need
Okay,
to do?
here we go back with that again. You're saying one thing, she's saying something else.
Well, I've got to move on a little bit here, which I think will get us over that hump, okay? I had not heard what she had to say to the supervisors today until you heard it. So if, in fact, her policy had been followed, then she would have called me to say, you're good to go with the 50 signatures. And I would have then certainly said, well, yeah, I'll be right up there, but you told me you were going to take it, but that's okay. I mean, I told you I wanted to take it. But she didn't call me because the technical irregularity occurred prior to December the 6th. It occurred on June the 6th. It occurred, the era, the Supreme Court era that I'm going to win this on occurred June the 2nd when her clerk negligently placed my papers into the wrong file.
Okay, when did you follow up to make sure it had been done?
It was after the deadline.
So you never thought about it not being finished? That never
No.
crossed your mind?
No, because
So
Anita had told
so
me.
as an attorney, you used to assume a lot of things.
No. We often ask others to deliver this to the judge.
Okay,
I'm
and-
going to hand this to the clerk, and the clerk's going to take care of this. That's very common practice.
Well, I think if I was going to apply for something and I make sure it gets done, I think I'd be checking up on it.
Well, that may be your personal thought.
No,
but
that's not. That's the way I would imagine you, being an attorney, would make sure that the thing was filed.
You may have an imagination such
Well-
as that. I have 25 years worth of practice where we trust clerks.
Okay.
We have a practice of trusting them to say what they're going to do, and I don't know why she didn't do it, but I suspect
Because
it
it
was
wasn't her responsibility.
No, she
It's
didn't do
yours.
it because her clerk put my papers in the wrong file.
And then you have a copy of those paperwork?
Sure I do.
Okay.
Ronnie
And
just gave me his
again,
copy.
You went around for how many weeks? 3 weeks? Something like that? 2 or 3 weeks? And never asked if it had been filed or followed up on it or anything?
Well, we expected to be notified, and if Ms. Ray had been conducting her policy and her deputy hadn't been negligent, she would have called me and said, Janice, we've checked off your signatures, come get your papers. She just explained the policy. Anita did not have my papers because her clerk put them in the wrong place. That's a technical irregularity.
So you're wanting us to make an exception is what you're saying?
No, I'm asking you to follow what the Supreme Court has to say.
Well, follow what the statute is and the law.
The court has interpreted the
Has the
statute.
Supreme Court made a new law?
No, they've interpreted the statute, which is their business.
I'm happy to advise the board. Obviously, this is.
Please do.
Yeah. Well, with it being pending litigation, it's really something that would qualify for executive session, but if y'all want me to talk in open session, I can. I would recommend we go into executive session, given the threat of litigation, to discuss it.
I would agree with that. If the attorney said that, I would, Mr. President, I would agree with going to
It's,
executive session.
and,
All right, the motion for closed determination.
Mr. President, we got a long agenda here, and some of these people might be want to go home. Can we just
Moving
go
on.
through this and then go executive session?
Okay.
So they got to go from work in the morning, department.
All right, Mr. Scott Weeks.